Welcome, everyone. Thanks for coming out today. So today, as Kyle said, we're going to be talking about how to make sure your loved ones are secure. So what you're going to discover today is how to guarantee your Valentine is properly designated as a beneficiary of your estate, care options, how to pay for long-term care, good estate planning documents, and what happens to my assets if I do not have a plan in place. Okay. So this is for you if you are unsure of how or where you're going to receive your care, confused about whether your property is properly titled, scared of not being able to make your own decisions, sick and tired of thinking about becoming impoverished paying for long-term care. So imagine that you could have a magic wand and you could have a plan in place. You would not be a burden to your families. You have a plan to protect your spouse and beneficiaries, avoid conflict in your family. Now, we can't guarantee that one, but we can do our best to have a plan to avoid that conflict as much as possible, and really have peace of mind. That's what we hear from our clients after they have their plans done. They have peace of mind. I know that I've done everything that I can do. So here's what our clients are saying. I found that the entire process went very well. They basically held my hand and walked me through everything. Their attention to detail was fantastic. I can't imagine going through it without someone like Steinbacher, Goodall, and Yurchak by my side. I needed things done concerning my parents, and they made everything seem easy and simple. Because of this, I didn't feel overwhelmed going through what was uncharted territory. These people received my highest recommendation. All right, I'm going to go back to that slide. So as introduction, my name is Tammy Zilske. I am a long-term care planner. I've been with the firm now 17 years this month. And prior to my work here at the law firm, I was a hospice social worker. And I also worked as a home and community-based care manager. So that gave me a really good background on what people need in the community. And why I continue to work at this law firm is my advocacy skills are really enhanced when I'm working with the attorneys, because when you have the law behind you, you can really get a lot done. So, so that's why I continue to work at the firm, and I'm going to tell you a little bit more about the work that I do when I go over my slides. And I'm going to turn it over to Pat Santucci, and he's going to walk you through some estate planning documents.
Hey, good morning, everybody. Thank you, Tammy. Like she said, my name is Pat Santucci, Clinton County guy, live in Lock Haven, Penn State law and Penn State undergrad previously, so pretty much bleed blue and white. Was in the Army for a long time and then did a career change in my 30s. And I primarily practice here in Williamsport. So if you come to the Williamsport office, that's where I'll be. We've already talked about her. This will be like our agenda. So what we're going to talk about today, care options that are available. We're going to talk about how to pay for long-term care. We're going to talk about some estate planning documents, and Tammy's going to talk about how you can protect your assets. So the most important document that probably everyone's heard about are powers of attorney. So this is what we're going to talk about first. Powers of attorney are where a principal authorizes an agent to act on their behalf. So that'll be the terminology. If you're creating a power of attorney, you're the principal, the person that you're identifying as your person who's going to be in charge of your power of attorney, that's your agent, okay? Basically, what these documents do is they authorize somebody else to act on your behalf. If someone is your power of attorney agent, they can sign your name to documents. Okay, we'll talk more about what those powers are and how they have to be specific because of the law and the way the laws are written. But generally speaking, a power of attorney is giving somebody the authority to act in your name, making them your agent. Now, common misconception is that like a spouse will be able to act in your name in all situations. That's not entirely true. If you have a joint bank account, sure, if her name's on it, she can get in there, but start working around and doing different financial things and you'll find out rather quickly, lots of financial institutions will not just let your spouse do things in your name, okay? Also, and importantly, medical institutions oftentimes have policies that will supersede your authority as a spouse. If you want to do something against medical recommendations, you better have a medical power of attorney in hand, okay? Otherwise, it's going to be based on whatever the policy is of the hospital. And they are bound by the guidelines created for them by the laws. What you would rather have, what most people would rather have, is the personal authority to make those decisions, not be left to the whims of a standard operating procedure of a hospital that is within the realms of the law, but you don't want to exist in that area. Most people would rather their medical decisions be made by a loved one who they know and trust, not by a hospital's whoever's in charge of making that decision for them. And today we're going to talk about 4 different kinds of powers of attorney. Here, we just want to point out a quick example at the beginning. What if you don't have a power of attorney and you become sick, injured, incapacitated, for whatever reason, you can't at this time create a power of attorney and you're incapacitated? Well, your loved ones, if they want to do something and they don't have power, they don't have agency to act on your behalf, they would have to have you declared incapacitated. So to do that, the court will have to find by the highest level of evidence in civil court, which is clear and convincing evidence that you're incapacitated. What that means for us in Lycoming County usually is that a neurologist or some sort of mental health care professional would have to evaluate you and determine that you're incapacitated. The judge would have to see that document, and in some cases, like if it's Judge Carlucci, he's going to want to talk to the doctor. Now, last time I did one of these, it was December, I think, when we were trying, somebody didn't have a power of attorney. Poor lady had to go to the hospital, and she needed to pay bills, she needed to move money around, et cetera, et cetera. We said, all right, well, do you have a power of attorney? There isn't one. The family said, what can we do? We said, well, we have to get a guardianship. First thing we did, we started looking for a mental health professional to have her declared incapacitated. We found a neurologist. It was December. He could get her in by May. We're still working with her, but in the meantime, she's working at risk, right? She's not as in control of her finances as she would be otherwise. Okay. Now, once you are found to be incapacitated, then we can petition the court to have a guardian declared. Now we have an incapacitated person. We have a ward that needs a guardian. That's the principal agent terminology when we go into guardianships. You're a guardian and a ward instead of a principal and an agent. But to get those powers, a court has to say that you're assigned as a guardian after finding incapacity in the person. So for what it's worth, it's more expensive than a power of attorney, but really where you're going to lose money is when you lose the time. Because that can take us 6 months to get a neurologist to say that you're incapacitated. It could take us a month or 2 to get on the docket in a court. And if it's contested, it could take several months. So if there's people in your family that disagree who should be the guardian, oh boy, now it gets really expensive in attorney's fees and time, because now we're litigating. We're going to be arguing against another attorney about who should be the guardian. Say that to say this: getting a financial power of attorney right now is a really cheap and really easy way to make sure that control of your finances will be held by you or held by somebody you name and you trust. These are the 4 powers of attorney that I'm going to talk about today. These are the 4 that, in my legal opinion, you should have, because the Pennsylvania, the way the laws are written, each of these has their own statutes and rules around them. And if you don't have each of these, you can run into unique problems for lack of each one. So we'll go over them. There it is. So we'll talk about the financial power of attorney. I think when most people say power of attorney, this is the one they mean. Financial power of attorney. So this one, you can open, close bank accounts, sell real estate, defend litigation, make limited gifts, the way we write them, make unlimited gifts, create revocable trusts, etc. Many financial powers of attorneys that we see don't include some very key things. Making unlimited gifts, and Tammy will talk about why that's important. Unlimited gifts is a term that's actually used in the statute that describes how these powers of attorney operate. So it's an important term. It's a legal term of art that if you don't know about it, you don't practice elder care law. You know, before I started practicing elder care law, I wouldn't have known about any of this stuff either. It doesn't mean attorneys are bad attorneys. It's just if you're a generalist, you usually write these and you never execute them. We execute all of them. So what you get with us is if you're getting a financial power of attorney from Steinbacher, Goodall, and Yurchak, you're getting one that's vetted every day. So they're used every day. We write them all the same way. We use the same terminology. We use them with the same financial institutions. And if they don't work, we rewrite them and we change the way we write them. So it's a document that is vetted over hundreds of iterations of use. So yeah, that's enough advertising for Steinbacher, but you want to use a specialist is the point, because people who don't practice in this area don't know how these documents get used. They understand the principle and the theory of the law and how they're supposed to work, but I think everyone knows how things are supposed to work and how they actually work sometimes turn out to be very different things. So this is Act 95. If you want to get on Google and look it up, you can find all this language that I'm talking about that says that you have to say things specifically or it's just not so. There used to be some financial powers of attorney floating around that were basically like, he can do everything I can do, sign here. That's not good enough anymore. And the legislature made it clear in 2014 in a law called Act 95. Healthcare power of attorney. This is the second power of attorney we're going to talk about. This authorizes your agent to make medical decisions, consent to surgery, admit to discharge from hospital, even against doctor's orders or recommendations, right? And then it'll also give you access to all the records you would need to be a good medical healthcare agent. So it'd have a HIPAA waiver in it, so that your agent will be as informed as possible when making those medical healthcare decisions. The mental health power of attorney. This one is unique in that it must be renewed every 2 years because it's a pretty powerful thing. And when this gets triggered, it must have a medical professional and a mental health care professional both agreeing that you are incapacitated, even though you may appear not to be. And it's a weird thing. Sometimes people, they're up, they're awake, they're talking to you, just like me, but they're not really capable of making decisions because of something else that's going on with their mental health. This is for if you are otherwise appear to be capable, but the way we write our powers of attorney, and people can do them differently, but it has to be in ours, 2 medical professionals. One's your attending physician and one's a separate mental health care professional that will both say, even though this person is conscious and they are speaking, they are incapacitated and they should not be making healthcare decisions for themselves. You see this a lot with dementia patients and things of this nature. You go long enough and down the Alzheimer's road, at some point you might be awake and we might be talking, but you really shouldn't be making like major medical decisions for yourself. And at that point, when that happens, your agent can show up with his medical power of attorney and begin making, or excuse me, mental health power of attorney and begin making decisions for you if you're in some sort of catatonic state. Okay, so that's the mental health power of attorney, and then we teed it up, the living will. This is triggered by when you can't communicate at all. And the way we write this is we say, even if you can blink eyes, once for yes, twice for no, or if you can squeeze a hand, then the living will doesn't count. Okay, the person makes the decisions right up until the point where you can no longer communicate with them. So once you can no longer communicate with them, a living will can become effective, and that's where you put out all the different things you want to make sure you include what could happen to you if you're not able to make a decision. The good thing about this is it's a lot of tough decisions that would be hard for anybody to make, especially if it was your mother or your father and you had to make these decisions. The good thing about a living will takes the decisions out of their hands. At this point, I'm no longer making a decision about what to do with a feeding tube, what to do with some sort of treatment. I'm not making the decision for mom and dad. I'm doing what mom and dad said they wanted done in their living will. Takes a little bit off of my mind as far as like I think about, am I going to think about for the rest of my life, did I make the right decision or the wrong decision? If you have a living will, your child's not going to have to do that, or your agent will not have to do that. They will simply have to do what you already said should be done according to your wishes. Also stops a lot of arguments. If there's more than one child in the room, there's going to be more than one opinion about what to do, and those arguments can ruin families. So if you make it clear what you want, then there's no decisions for anyone else to make, ergo, a lot less drama in the family. That's why a living will is important. But it's also important because it points out that you don't want certain things done. Oftentimes people point out that, if I'm incapacitated and there's no hope of recovery, and you got 2 doctors who have said there's no hope of recovery, I don't want a feeding tube inside of me. Don't do that. Don't take measures that are going to just prolong my existence, even though my demise is ultimately going to happen. But I can also say things like, but please make me as comfortable as possible. If I'm on my way out, administer all drugs you can think of that might make me more comfortable. You can put things like that in there too. These are very common things you'll find in a living will, and that's a quick synopsis of why I think it's important, why I think probably everybody should have one. So the big distinguishing line between powers of attorney and wills and trusts is your life. When your life ends, then it's about who's the executor of your estate, and that's going to be found in your will. Or if you die without a will, it'll be operation of law will decide. And that's and you go through it, it's usually the spouse, then it's the children, no children, brothers, grandchildren, no grandchildren, grandparents. So there's like a way that the law operates if you die without a will. But generally speaking, after your death, your will control what happens as far as your estate. That's all the stuff you have. This is the big thing I was talking about earlier, the distinguisher between powers of attorney and wills, is that powers of attorney exist during your lifetime, and then the will becomes powerful the moment of your demise. And then a trust can be in both. Trust can go across generations. So it's a written instruction, the will is, about what you want, just how you want your assets distributed upon death. You designate an executor. That would be sort of like your agent or power of attorney or your guardian, but it's the person who's in charge of your estate, who's going to divvy out all the things and be in charge and be charged with fiduciary duty to your estate, which means that person who is assigned as executor must do what's right for your estate and best for your estate, notwithstanding any of what that person needs, right? So the fiduciary has to put the needs of the estate above their own needs. Okay? Then you'll also designate testamentary guardians if you have anybody in your will who are below the age of consent, so under the age of 18. We do generally up until age 25. I think seems like people are wanting older and older. I know a lady who wants it 30. But it depends on how much you trust your kids, when you think they'll be adults, when you think they'll be ready to take on whatever assets you're given. Also, it's the size of the asset, I feel like I could be, as a 20-year-old, trusted with a few $1,000s, but if it's $1 million estate, you probably want to wait until I'm like 30. Otherwise, you're going to have a Lamborghini and no estate. So you can designate also the custodians under that's what we're talking about, under 25. And yeah, that's big, broad picture what a will is. I think most people understand it's how you take all the things you have in your estate and distribute them after your demise. So self-proving, we talked about this. I got a little ahead, I guess, of the slides, but we do this so that when your will comes forth, it doesn't need witnesses to testify that it was in fact signed by you. And then there's some will substitutes. These are things that bypass your estate. So if you have like a life insurance policy and you assign beneficiaries to that, that is going to go directly to your beneficiary, not to your estate. I think IRAs are sometimes like this, retirement accounts sometimes like this. Anything that you're signing a beneficiary on may be one of these things that does not go to your estate, but rather goes to the person you assigned in the paperwork. So like life insurance policies, the life insurance policy controls, not some will or testamentary law.
I guess you should keep things up to date, but let's say your spouse is your beneficiary on a lot of this stuff.
Mm-hmm.
Now, your spouse passes away, and you just didn't think to change all these beneficiaries. Then what happens to those accounts or whatever?
It's a great question, and you really teed it up here. So what happens is, if you set this up so that like my stuff goes to my wife, but then my wife predeceases me, what happens to that stuff? It goes to my estate. And the difficult thing about that is, if say I'm in a personal care home at like $450 a day for several years, and then my wife predeceases me, there's going to be a lot of assets that would have gone to her, and probably through her will would have gone to our heirs, our children, our grandchildren, our nephews, our nieces, or charity that we chose. But instead, it's going to come back to me. And I'm, remember in this example, in a personal care home. So probably all that money is just going to end up being the personal care home's money once they put a lien against your estate. And like you'll see, all wills have like as a second or third paragraph that like the estate will pay all its taxes and it'll pay all its bills. And that's where that personal care home is going to come in. And everything else you say in your will doesn't really matter if all your assets get eaten up by personal care, right? Or Medicaid, or any, like I'm dealing with one right now where a guy spent 108 days in a VA healthcare or a VA care facility before his death, and they hit him with like a $78,000 bill. Now they're taking his house from the state. We're trying to fight it, but that's just one example. So great question. I like where your head's at. Leads us straight to this example. If though they had a will that, or excuse me, if she had an alternate beneficiary, then that's it. So the lesson here is, if you do have these benefits and you have one person on it, you need a beneficiary, a second one. Otherwise, those benefits will just bounce right back to you and your estate and be at the mercy of whatever's happening with your estate at the end of your life. It's a tumultuous time for your estate. A lot of people trying to get a piece of it. We can talk taxes now, which is something that I believe Tammy knows a lot more than I know about. So at this point, I'm going to hand it over.
We agreed that I would take this part.
That's the only reason I'm here.
Which is a funny story, because when I first started here, I said to Julie Steinbacher, do I really need to understand taxes? And she said, yes, you have to understand this. So we're not tax professionals, so there might be some questions that you have that I'm going to say, call your accountant. But I can tell you some of the things that you need to know regarding estate planning. So Pennsylvania inheritance tax. So as Pat was just talking about your will, the one thing that you have to be aware of is you live in Pennsylvania and we still have inheritance tax. We're one of the very few states that does. So who will pay that tax? That is up to your beneficiary. They are legally responsible to pay that. Now, in the last will and testament that we create here, and this is pretty common in wills, it will say that my estate can pay the inheritance tax first, okay? Situations where that might not be available is, let's say all you have in your estate is real estate, okay? So there's no cash to pay the inheritance tax. So then your beneficiary is going to have to come up with a way to pay that if they don't plan on liquidating that property, okay? So just keep in mind that, you know, it is up to your beneficiaries to pay that inheritance tax, but, you know, hopefully there's enough money in your estate to do that, okay? Inheritance tax rates are 4.5% for children and grandchildren. And then if it goes to a sibling, it's going to be 12%. And if it goes to nieces, nephews, friends, anybody else, that's 15%. So it gets pretty high. Nonprofits are exempt, okay? So that's something to kind of keep in mind if you, you know, especially if you have things like IRAs. You know, sometimes people are trying to avoid not only the inheritance tax, but the big tax that would be paid for retirement accounts. You can leave, you know, your retirement accounts to a charity, and they're not going to pay any taxes. Oh, and I should go back and say spouses are 0%. Okay, your spouses are 0%. Okay, oh. So if you leave anything to your spouse, so far Pennsylvania says 0%, but they have a percentage there, so I think it means that they could change that. And I get this question every day because people ask, well, the federal government says I can give away a certain amount of money per year. Can I do that? Yes, you can do that, but you probably don't need to worry about that unless you have more than $13.6 million, okay? So if you were to pass away with more than $13.6 million, then your estate could be taxed at 40%. You should really talk to an attorney if you're in that, because there are ways to avoid that.
And you can afford one.
Yes, and you can afford one. But, if you have less than that, then you don't have to worry about your federal estate being subject to that tax. You're gonna have to just worry about that Pennsylvania inheritance tax, okay? So that whole, can I give away a certain amount? I'm thinking it's 18,000 per year for 2024 that you can give away. That's really for people that have a federal estate tax that they're trying to dwindle down their estate, okay? Those are not Medicaid rules, so don't get confused and say, well, I can give away all this money to my family and then get Medicaid. Guess what? They don't acknowledge that. So when I talk about the 5-year look back, I'm going to mention that. Okay. So if a federal state tax return is filed, you have to do it within a certain amount of time. So again, if you feel like your estate is over $1 million, it is a good idea to meet with attorneys, even though it's currently the $13 million, because it's really subject to change. This is a federal law that does change. And so what we try to do here at the law firm is if anybody has over 1.5 million, we put them in what we call wealth protection category so that we can keep an eye on the law changes, because it's based on what the law is when you die. Okay, well, we don't know what that law is going to be when you die. So we just try to keep a special eye on those kinds of clients. So just as a wrap up to the will, as you know, people were questioning, keep your original will. It's very important. You shouldn't keep it in a bank's safe deposit box because your executor can't get in there. So having a fireproof box at home is a good idea. Making sure your executor knows where to find that will at the time so that they can retrieve that. When you are putting together a will, you also want to make sure that you pick executors. You can pick one, you can pick two, but you should also name it a successor executor. Yeah, question. But I did want to say you should name a successor executor because you never know your executor may pass away before you, and you want to make sure that you have somebody in mind. You can name multiple executors, successors, so you could have like 5 different people. You're not just limited to 2. All right. So what is a trust? Okay, so I do want to mention the whole 4D thing that he had brought up. So the things to be concerned about. Years ago, attorneys would just say, just put your property in your kid's name. Okay, transfer for $1. Okay. And do we all know why that's a bad idea?
We can turn on. Yeah.
So first of all, they could have a disability themselves. Okay. So we see a lot of things here in this practice. I had a situation where somebody transferred property to their son, regardless of our recommendation not to do that. He went to a nursing home. Guess what? Lost that home to the nursing home. So your child could get disabled before you. Your child could pass away before you. So you gave them your property. Well, they have a will, and if they don't have a will, the state has a will for them, and that will might be, oh, it goes to their kids. So you're still living in your house. You gave them the property. They died. You don't own your home anymore. We've seen terrible things. So that's a bad thing. So how about debt? Okay, so let's say they get in a car accident, no fault of their own. Somebody sues them beyond their insurance, and now all of a sudden there's this huge debt. Well, those creditors want to get paid. They could come after that home because that kid owns the home. Okay. So there's divorce is the other one. So let's say they get divorced, and now the property is subject to their divorce. So those are reasons we don't like to transfer property to a child. The other thing I want to mention that I don't think is in the slides here is taxes. Okay, so let's say none of those bad things happen. I give my property to my son, he gets what's called a carryover in basis. So if I paid $100,000 for my home, I give him that property, he goes to sell that property later on, he gets a capital gains on that property. Okay, so if he sold it for $300,000, he's got a $200,000 capital gains at the lowest rate, 15%. That's a huge tax bill. Whereas if I would have just left it to him in a trust or through my will, he's just going to pay inheritance tax and he gets a step up in basis, which means that if the value is 300,000 when I die, he pays 4.5% of that, not 15% of the difference. Okay. So that's just a little background on why you should just give assets or property away. We talked about that 12-month look back with inheritance tax. So yeah, they might not pay inheritance tax, but they're going to pay capital gains tax, and that's sometimes worse. Okay. So a trust is really a vehicle that allows you to, I think there's a slide about it. It allows you to transfer ownership of property, but keep control of it and guarantee that it doesn't go to, as Pat said, a personal care home when you die. It doesn't go to people that you don't want it to go to. It goes to the beneficiaries that you intended. So a lot of people come in and say, well, I have a will, isn't that good enough? So a will only distributes to the beneficiaries after your creditors get paid. So if you're in a nursing home and the state of Pennsylvania pays $300,000 for your care, and your properties were $200,000, they get all of that, okay, through a will. If you had your house in a trust, they can't get any of it. Okay? It fully goes to your beneficiaries. You can see why a trust is a really, really important legal document if you want to guarantee assets go to somebody. Now, in order for that to be effective, the trust has to be irrevocable. And I always tell people when they sit down with us, don't get scared about that. Because even though it's irrevocable, you keep a lot of control with the trust we prepared. And that's not true of every law firm because we review trusts at other law firms. So with the trust at our law firm, you can be the manager. We call that the trustee, okay? So if you put your property in there, you manage that property. Nobody else decides. You can sell your property. This is a biggie. So let's say I put my house in the trust. 10 years from now, I said, this house is too big. I want to sell it and buy a new one. I can sell my property. The check is payable to my trust. I'm the trustee. I can buy another piece of property with it, okay? So let's say I move to an apartment and now I've got $200,000 in the name of the trust. I can manage that money. I can decide if I put it in CDs, a money market, whatever I want. I can't withdraw the money. That's the irrevocable piece, okay? So you have to be okay with that. But we do give you an escape hatch in our trust, and that's called the trust protector. So those are two people that you designate when you're setting up the trust that can withdraw money for you if you need to get it out, okay? So let's say that I only have one child. So let's say it's my son and my niece. They have to work together. I make them work together. They can take the money out, they can give it to my son, and then he could pay for what I want. Let's say I want to buy a new car. He could take it out and he could buy the car for me. But let's say him and my niece say, we don't want to take that out. That's our inheritance, okay? In the document, we give you the power to make amendments, okay? The first amendment I would do is remove them as trust protectors and say, guess what? You guys are out, I'm going to put somebody else in there. So I'm really keeping control, okay? And then I could also change who receives it when I die. Guess what? It's no longer your inheritance, it's somebody else's inheritance. So that's a really important thing to kind of keep in mind when you're thinking about irrevocable trust, is that, you know, do you have the control that you want and the protection that you're seeking? So a trust is a legal document with a set of rules, okay, and you set it up through the law firm. And then as far as like what you put in there, you decide where that money's invested. So, you know, if it's real estate, then it's just a new deed for your property, okay, titled in the name of the trust. There's no bank associated with it or anything like that. But let's say you had an investment account with Edward Jones and you owned it, but you want to put it in the trust. We just do a change of ownership. So now the trust owns it instead of you. And then if you have a falling out with Edward Jones and you want to move it to PNC Bank, you as the trustee have the power to do that. So you're in charge of it, not a trust department. Sometimes people do appoint trust departments to manage their money just because they don't know how to manage it. So that's an option. And you would never put your bank account in it that you intend on using, because again, of those restrictions. Like, so we're not putting your checking account in there. We're not putting your, savings in there that you intend on using. This is really earmarked towards stuff that you're not planning on using, but there's a way to get it out if you need to. So anytime you make a gift to a person or trust, and then you're asking Medicaid to pay for care, they look back 5 years. Yeah, that's why you want to do this kind of stuff in advance. So I do want to just mention, there are revocable trusts and irrevocable trusts. In order for it to offer the protection we talked about, it has to be irrevocable. But I told you how you still control it. A revocable trust, why would somebody want to set one of these up? So a lot of times they were used for federal estate planning to avoid that federal estate tax, because of the way the trust terminated when you passed away. And but again, unless you have more than $13 million, we're probably not going to recommend a revocable trust. The other way that Pat and I do a lot of revocable trusts is, let's say you want to leave something to a beneficiary, but they have issues, okay? Maybe there's a divorce that's pending, or maybe they have a drug problem or a spending problem. Instead of leaving them money, you can leave it in a revocable trust so they can get access to it, but it has some creditor protection. So that might be a situation where we would be using that type of trust. So it's really helping people individually look at their assets, figure out what their goals are, what their plans are. We meet with some people that say, I don't care if my beneficiaries get a dime. It's really customized based on what you want, okay? So what would you do next after you learned all this information about estate planning? Meet with our office. We'll review your documents. We'll make sure they're up to date with the current laws. We help you, get good legal documents so that your agents aren't running into problems, and avoid putting your family in a bad situation. So another satisfied client said, these people are thoroughly professional. I'd worked with them a few years back on some needs. Then they also assisted in helping my mother get Medicaid approved. Their skills always impress me. They get things done in such a timely manner. They also did my brother's will and power of attorney. I would wholeheartedly recommend Steinbacher, Goodall, and Yurchak. So we talked a lot about estate planning. So we do different levels of care. So basic estate planning, just powers of attorney's wills. We do the trust work. We also help people in crisis, and that's really going to be what we're going to talk about next. What we're going to talk about when people come in here, if they're at home still, is what are your options? Where do you want to live? Do you want to live at home? Do you want to live in a facility? And so at home care, would be hiring caregivers to come in. One of the things I want to mention that I see a lot of that is a big mistake is just hiring people privately without a contract, okay? I just hire my neighbor because she's a nice lady to come in and help me. Well, guess what? She hurts her back taking care of me, and I haven't been paying workman's comp. She could sue me. I could lose everything, okay? So if you do want to hire people off the street, that's okay. Make sure you talk to our office about a care agreement and a contract that protects you. Private duty care at home, our county, $20 to $30 an hour, okay? So if you're looking at 24-hour care, that might be $18,000 or more a month. Sometimes in-home care, if you need a lot of it, can be very, very expensive, okay? If you need just a couple hours a day, that's okay, Since Wendy's here from Geisinger Life, another option for in-home care that is really a neat program is called the LIFE program. The LIFE program is a comprehensive medical model where, as an alternative to nursing home care, where you get the advantage of going to a center during the day where they have a number of medical things, therapy, dietitian, your doctor's there. So, if you were in a rehab and Medicare says, we're not paying for rehab anymore, And then you start to lose the ability to, you know, ambulate and do things on your own. With the life program, they look at you and they say, you're going to need exercise the rest of your life. So it's a really beautiful model. If anybody's not familiar with it, tap into Wendy at the end. She'll talk to you a little bit more about it. Where I like using the life program is especially if somebody has dementia and, you know, you've got a spouse caring for them, because this program has activities that are really geared towards helping engage that person where they're at, instead of you trying to bring them into your world. And so I told Wendy I was going to tell a cute little story on an adult day program that I worked with a client, and the spouse sent him to the program and he loved it. He was helping, folding cows, you know, they had all sorts of activities for him. But he said, what I don't like is they don't pay me. He thought it was his job. And so we were like, not a problem. So we gave an envelope full of $1 bills to the program. They gave it to him at the end of the week. He was satisfied. He was getting paid for his services. So really, really neat program that's alternative to nursing home care. Facility care, I think we all know about nursing homes. Nursing homes are usually a place that nobody wants to go, but I'll tell you what, when I'm trying to get somebody in a nursing home, it's pretty hard to get a bed. So they're full of people that don't want to be there. So don't ever think, well, I'm never going to a nursing home. You just don't know. You don't know what the future brings. Assisted living, personal care homes are another alternative to nursing home care. Really great options. About a third of the cost of nursing home. You have to meet level of care. So if you're somebody who's bedbound and needs a lot of care, you can't go to that type of facility. So you have to have some level of independence for that. How do you pay for care? So you're going to see that there's different ways. Private pay, obviously, pay out of pocket. Veterans benefits. So veterans benefits are available to veterans. So Pat had mentioned a veterans home. So if you're a veteran, you can go to a veterans nursing home. There's just none here in Lycoming County. At one point, Roseview was contracted with the VA. So if you were 100% disabled, you could go there instead of going to Altoona or Wilkes-Barre. But veterans benefits that I'm talking about is a pension that you can get. So there is a non-service connected disability pension. So if you served during Vietnam War, at least one day, you were in for at least 90 consecutive days, and that didn't have to be during the war period. You were honorably discharged. You or your spouse could get a pension to help pay for in-home care, for the life program, assisted living, or nursing home. Now, I don't often advocate for it for nursing home because nursing home bills are $11,000 a month. The pension maximum you can get is a little over $2,000 for veterans with a spouse. Okay, so it's not going to really help. Where it really helps is in-home care, assisted living care. Okay. So if you guys have any questions about that, we do have a brochure that Kyle's put together that gives you some more information. Long-term care insurance. So long-term care insurance is something you need to buy in advance of needing long-term care. You can't have a diagnosis of dementia. You can't have a medical situation where the company knows they're going to have to pay out. So when do you get long-term care insurance? In your 50s, your 60s, okay? And you pay for it for a very long time. All right. So you are, you know, in your 70s, I got a quote for somebody for long-term care insurance in their 70s, it was $13,000 a year. Okay. It's more expensive the older you get because the higher risk that they're gonna have to pay out. Long-term care insurance is something I strongly encourage people to get if they can qualify for it because it offsets your liability. You got a policy that pays out $400,000 and maybe you pay $10,000 a year for it and you can afford that. Wow, what a benefit. You know, so it's something you have to kind of weigh out. Medicare benefits do not pay for long-term care. I think we all know that Medicare is short-term. And even though you can get up to 100 days of Medicare, they don't always guarantee that. So if you are in a nursing home rehab after a fall, and you can't bear weight anymore to, you know, do the exercises, you go off Medicare and now you're private pay. The Medicare wasn't intended to pay for long-term care ever. Medicaid is what most people are going to need to pay for long-term care. But Medicaid is something that is a needs-based program, so you have to financially qualify. So that is something that we can help you with here. And it's too much of an animal for me to go into that right now, because there's a lot of factors that go into qualification for it. So what we recommend people do is have a good long-term care plan. So if you can get through 5 years, we're going to talk to you about trust, because they're a guaranteed way to protect assets. We're going to tell you don't transfer assets to a child, put them in a trust. We're going to have a plan for you. If you come in here and you're in crisis, we can still help you. It's not going to be the same level of help that we would have given you if you would have come in advance, but there are still things that we can do. But you have to get in here as soon as the crisis hits. So we tell our clients, clients that just come in for estate planning, hey, if you ever go into a nursing home or your spouse goes into a nursing home, call us when they're in the hospital so that we can help you. You haven't done asset protection planning. We want to see what we can still do to help you. Okay. And then we're going to put together a puzzle for you. It might not be the puzzle you like, but it's going to be the puzzle that we can put together. So that's, we're really creative and trying to find ways to protect assets. But I can't emphasize enough that, having a plan in advance of the crisis is the most important thing. So, and a lot of people will say, aren't trusts for rich people? The answer to that is no. The trusts are really for anybody who's accumulated something that they want to try to protect. So I would say probably most of the clients that Pat and I serve, they have less than a couple $100,000. Their house is the most important thing to them because they put a lot of money into it, a lot of time. It's sentimental to them. So trusts are not just for people that have, millions of dollars. So putting a plan into place. So Kristen Doherty is from our state college office. She and I are certified Medicaid planners. And so she and I have been working at the firm for a long time. It takes a lot of special training to become a certified Medicaid planner. What Kristen and I do when we're meeting with clients in planning situations is, like I said to you, sir, we look at everything you have. We have a discussion with you about your goals. We help you put a written plan in place, okay? And why this is so important, this is not something every law firm does. Law firms will say, come in, sign your wills, you're done here. They don't talk to you about beneficiary designations. They don't talk to you about these things. These things are important because your goals are not going to be accomplished if you don't have a written plan. So written plans are very important to us, and then helping people to implement them. So the other thing I just want to throw out there, and I won't spend a lot of time on this, is people will come in here and say, well, the nursing home will do the Medicaid application for me for free. Why should I pay an attorney to do that? I'll tell you why. Because filling out a form, when you probably see this in your language, filling out a form and providing legal representation is 100% different. What I see when people use the nursing homes, when they might have assets that could be protected, is they get a denial of Medicaid, and now all of a sudden they've got a huge nursing home bill. You come in here with that bill, I can't do anything about that. You have to pay that. So we can make sure that the law is being appropriately used. So that is why it's really important. I know this is not you guys because you're here learning about this, but if you know anybody and they say, well, the nursing home's going to do it for free, just remember it's not free, because it's going to be $11,000 a month until you get Medicaid. And getting Medicaid is probably one of the hardest applications you can ever file. So I have a staff person who goes through 5 years with all of your investments and figures out what Medicaid is going to flag. And we have a plan in place so that there are no issues. Okay, some things, if you've done some things, you may have to pay the price for it. Like if you gifted asset, there is that 5-year look back. We're going to have to deal with that, but we can deal with that in advance if we know about everything. The other thing we already talked about is if Medicaid pays for your care, they're coming after your estate. So there are some assets they don't count, like your house, but they will come after your house when you pass away. So that's why a trust prevents that. So what do you do next? So the one thing I hope that you'll learn today is that really planning ahead is essential to make sure that your family is safe, and that you don't spend more than you want to on long-term care. So what we do is we would have a meeting with you where we would review your estate planning documents, your assets, if that's something you're interested in, and then we help you develop a plan, answer any questions you have, and kind of walk you through next steps. You know, and having a plan in place doesn't mean that you're not going to get in crisis. You may have that medical event, but at least you're going to have peace of mind to know what's going to happen when that occurs. So what's the catch? There's no catch. Like, you know, peace of mind. We will go through the fees with you based on what you want to hire us for. So there are different set fees for different packages. So we would talk to you about that.